breath. Oh my gosh, did it work? I don't think it worked. I don't think it worked. Did it work? It didn't work. It didn't work. Oh, it did work. Yay! Okay. Oof. Now we can go back to this. We might hear a little bit of extra, but I need to just rather cover the base that potentially I skipped some. Okay, I know we heard all of this guy. So we should be about, we heard him, should be about here.
Inspector Bassford, you remain under oath. Please speak loudly and clearly into the microphone. No need to place you under oath again. Ms. Jeffcoat, your witness.
Thank you, Your Honor. Inspector Bassford, the incident where we watched the video where Captain Sanders was thrown to the ground.
Yes, ma'am.
That happened on Graceville CI campus, correct? The
Yes,
FD
ma'am.
Institute. Is that, what county is that located in?
Jackson.
Jackson County. All right. Thank you. I have no other questions, Your Honor.
Does the defense wish to cross-examine this witness?
No, Your Honor.
All right, Inspector Bassford, you're still subject to recall on your subpoena. All right, ladies and gentlemen of the jury, this is a good time for us to take our lunch break. The time is 11:34. We will continue to do some work while you guys take a lunch, and I need to give my staff an hour lunch break. So I'm going to ask that you guys come back at 1. And that'll be about an hour and 25-minute lunch break. And at that time, we will resume the trial. Please remember, you may not have yet heard all of the evidence. You have certainly not heard the attorney's arguments or my instruction in the law. Please do not form any definite or fixed opinions regarding this case until such time, and do not speak about the case either among yourselves or with anyone else. And we will let you go to lunch, and we'll see you guys back at 1 o'clock. Thank you very much. Let the record reflect that the jurors have exited the courtroom. The state is still present. Counsel for the state, counsel for the defendant, and the defendant are still present in the courtroom. The state has now rested. Is there anything from the defense at this time?
Yes, Your Honor, at this time, we would move for a judgment of acquittal. Based on the nature of the offenses, the state has to prove that the defendant's conduct rose to the level of culpable negligence at the very least, and we don't believe that the state has proven that at this point, so we would move for judgment.
All right. Response from the state.
Your Honor, the evidence viewed in the light most favorable to the state shows that the defendant picked up Captain Sanford, threw him to the ground. As a result, Captain Sanford was injured, that it was a serious injury requiring surgery, and included a fractured femur, that ultimately a blood clot developed in the location of the fracture and traveled to his lung, which ultimately killed him. With that, Your Honor, the state believes that the evidence is sufficient to go to the jury for this offense and all the lesser included.
The court is reviewing the proposed instruction for aggravated manslaughter. In that proposed instruction, the court, considering the evidence in the light most favorable to the state, must consider whether or not there's sufficient evidence for this jury to make this determination as to whether or not the defendant is guilty of this offense. 1, the state would have to prove that Matthew Sanders is deceased, and that has been testimony provided by both his wife and Dr. Radke. 2, that the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. The court has heard testimony that in March, Joshua Lawson picked up Mr. Sanders and threw him over his shoulder, breaking his femur, and has seen video to that effect. The court has also heard testimony by Dr. Radke, where Dr. Radke opines that the decedent's cause of death is a blood clot in the lung that originated from the broken femur and the resulting immobility from that leg. the state would also have to prove that at the time, Matthew Sanders was an officer who was at the time performing his duties within the course of his employment. And certainly there has been the testimony of numerous witnesses that at the time of the incident between the defendant and Matthew Sanders, that Officer Sanders was acting as captain. That's the reason the inmate was taken to the decedent, because he was the captain and that was the next in the chain of command. The instruction on culpable negligence indicates that culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Even assuming that the defendant wouldn't have known that this was likely to cause death, swinging someone over your shoulder, and body slamming them onto a concrete floor would certainly be conduct that should reasonably be known to cause great bodily harm. And accordingly, the court finds that there is sufficient evidence for this matter to go forward to a jury. And so the motion for JOA is denied at this time. Mr. Lawson, I've already placed you under oath, and I'm going to go through a colloquy with you, but I don't want you to tell me your final decision yet, okay? Because I want you to have more time, or as much time as you need, to speak to your attorney about this. Mr. Lawson, in any criminal trial, a defendant has the absolute right to remain silent. Do you understand that you have that right?
Yes, ma'am.
All right. If you choose to remain silent, I will instruct the jury not to hold that against you, just like I instructed them not to hold it against you in the beginning of this trial. Do you understand that?
Yes, ma'am.
You can testify if you wish. However, if you choose not to, you can testify if you wish. However, if you choose to testify, your testimony will be considered just like anyone else's. Do you understand that?
Yes, ma'am.
The state will be able to cross-examine you, just like the defense has been able to cross-examine all of the state witnesses. Do you understand that? The state will be able to ask you whether or not you are a convicted felon, and because you were in state prison, it's my understanding that you are a convicted felon, and that testimony would go towards your credibility. Any prior felony convictions or misdemeanor crimes of dishonesty. Do you understand that? All right. Your attorney can give you advice regarding whether or not she thinks that you should testify. However, I need you to know that the decision whether or not to testify is ultimately your own. And even if your attorney says you shouldn't testify, if you want to testify, you can. Do you understand that?
Yes, ma'am.
All right. So during the lunch break, I want you to speak to your attorney about whether or not you wish to testify. And at the end of that break, I'm going to ask you whether or not you've had enough time to talk to her and what your decision is. Okay?
Yes, ma'am.
Ms. Kelly, certainly not going to hold you to this, but do you anticipate any defense witnesses?
At our last conversation, Mr. Lawson indicated that he did believe he would testify in his own defense, and
Fair enough.
that would be
One.
sole defense witness.
The sole defense witness. Fair enough. Okay. So anticipating that, is there any reason we can't do a little bit of charging conference? Obviously, we will amend the charging conference. The final charging conference will occur after Mr. Lawson has decided whether or not he wishes to testify. But most importantly, I want to talk about the lessers. Okay. Any concerns on the introduction to homicide? Can I get these in digital form too?
Yes, Your Honor, I
Sure.
can, do you want me to email them to Ms. Birch, or do you want me to just pull them up on the screen?
No, you can, it doesn't have to be right now. We can email them to Ms. Birch and Ms. Kelly, and that way I can have digital copies too.
Sure, Judge.
Anything on the introduction to homicide instruction right now?
No, Your Honor.
All right, and then, so the crime charge is aggravated manslaughter. And is there no break in the culpable negligence on the standard? It just seems like a really long paragraph, but
I'll double check, Your Honor. I think I always try to copy everything directly. from
Sure.
the course
I went
before
through
it goes
line by
out.
line, and I think it's pretty much,
there's no break in the paragraphs? Okay, fair enough. And then the lessers that you guys have proposed are manslaughter, aggravated battery of an officer, culpable negligence, felony battery, battery on a law enforcement officer, battery, and culpable negligence. Is that right? All right. Is the defense asking for all of those instructions?
yes, Your Honor, I think culpable negligence is category 1, and we had asked for the remainder is category 2.
Let me look.
Your Honor, for aggravated manslaughter and culpable negligence are both category 1 lessers. The remaining lessers are by case law, and I can give you a case site that helps.
So manslaughter and culpable negligence are category 1, to which the defendant is entitled.
Correct.
And the category 2s only come in if there's sufficient evidence to support those category 2s.
That is true, Your Honor, but I think they got kicked off of stack. Let me see, go back to it. But the standard jury instruction for aggravated manslaughter doesn't list any category twos. All of those aggravated battery, felony battery, battery on a Leo, those are all by statute or by case law. But I
Okay.
can provide you a site.
Do you dispute that that's appropriate?
Oh, no, I don't dispute that that's appropriate. I mean, it says that they're entitled to it, or that the state and defense can be entitled to those, but
All right, so like when they're lesser included crimes or attempts, that's all bold, whereas ag manslaughter is not. So we need to make sure we change that, or at least it looks all bold. So ag manslaughter looks different than introduction to homicide and when they're lesser included. We just need to make sure we take out the bolds or leave the bolds, but everything's got to be the same.
okay, Your Honor, I will,
Does that make sense?
sure.
Do you see how ag manslaughter looks different than all the others?
Yeah, it looks lighter than.
Yeah.
I don't know. I think when there are lessers, actually looks bolder than ag manslaughter or manslaughter. So I think that might be the one right now, but I'll check and make sure they're
Yeah.
all the same.
I think it's a different font.
It might be, yeah.
All right, so Ms. Kelly, you want all of those on there, correct? All right, so then we've got the manslaughter, ag battery on a law enforcement officer, and let me look, on manslaughter, one, that the decedent is dead, two, that the defendant intentionally committed an act or acts that caused the death of Matthew Sanders, or the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. I think there's sufficient evidence on that. Aggravated battery on a law enforcement officer, one, Joshua Lawson struck Matthew Sanders against his will. In committing the battery, intentionally or knowingly caused great bodily harm to Matthew Sanders. Three, Matthew Sanders was an officer. Four, Joshua Lawson knew Matthew Sanders was a law enforcement officer. And five, Matthew Sanders was engaged in the lawful performance of his duties when the battery was committed against him. I think there's evidence of all of that, even without the defendant testifying. As to felony battery, there's two elements. One, Joshua Lawson intentionally touched or struck Matthew Sanders against his will. And two, Joshua Lawson caused Matthew Sanders great bodily harm, permanent disability, or permanent disfigurement. I think there's sufficient evidence for that to go to the jury. Battery on a law enforcement officer requires four elements. Again, intentionally touched or struck. Two, the decedent was a law enforcement officer. Three, defendant knew decedent was a law enforcement officer. And four, Matthew Sanders was engaged in the lawful performance of his duties when the battery was committed. I think there's sufficient evidence for that. Battery, Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. Certainly there's enough evidence there. And culpable negligence. To prove the crime of culpable negligence, we need two elements. One, Josh Lawson inflicted actual injury on Matthew Sanders, and two, he did so through culpable negligence. And the definition of culpable negligence there is a little bit different than the definition of culpable negligence in aggravated manslaughter, right?
I think the one in aggravated manslaughter adds a little bit to it because I was going through. So I think the first several sentences, well, first, I was cutting and pasting and comparing and contrasting, and there are some slight differences in them, but this is the standard jury instruction for culpable negligence, and then the one for aggravated manslaughter has a couple of additional sentences based on the standard.
Okay, fair enough. And then the others seem to be standard, and we'll address those individually once all the evidence has been presented. Anything else preliminarily that we need to look at on the proposed jury instructions?
No, Your Honor.
Anything from the defense?
No, Your Honor.
Do we have a verdict form yet? Or you can email that to me. Email that to me, and then we'll get a good, clean copy of everything once we're all done. All right, then let's be in recess. Let's come back at 55 after. So 12:55. The time is now 11:50. That way everyone gets a full hour lunch break, and then we'll be here a little bit before the jurors so that we can get started right at 1.
The only thing on the culpable negligence instruction, there's a extra sentence that says actual injury is not required that I left in. It is part of the standard instruction, but it says if 1A is alleged and the state's alleged 1B, because 1A is, instead of inflicted actual injury, is exposed the victim to personal injury. And so I would just propose that I remove that sentence, but.
Are you in a position to discuss that now, or do you want some time to think about it during lunch and then look at it and then tell me?
And that's just for the misdemeanor culpable negligence.
It was removing the sentences of actual injury is not required.
Yeah, because in the italics above it, it says give if 1A alleged, and 1A would say that the defendant exposed the victim to personal injury rather than 1B, which is what I have in there, which is the defendant inflicted actual injury on the victim.
I don't have an objection to removing that sentence.
Fair enough. Then that will be changed on the proposed jury instruction. All right. See you guys at 12:55. We'll be in recess. Shut down. Thank you guys can we go off the record? Jeannie? Thank you guys for getting Radke here sooner.
Yeah, I
And little Dutch chocolate bars, so I can't eat.
You can do what?
I can't eat a lot when during this, so I just went and
Oh,
got
sure.
chocolate water, and those little kind bars at McCoy's, and
I used to not eat at all, but now I feel like I need to regulate my blood sugar more. So you can make a sandwich and eat half of my sandwich.
Some might help.
Have some protein.
during that trial with Bill,
All right, we are back on the record in Jackson County case number 21 CF 610. This is the case of the state of Florida versus Joshua Lawson. Present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. The jurors are not present in the courtroom. However, the jurors are back from the lunch break. Mr. Lawson, before we went on the lunch break, we went through a colloquy regarding your right to decide whether or not you wish to testify. Do you remember that colloquy?
Yes, ma'am.
During the lunch break, have you had enough opportunity to speak with your attorney regarding your decision to testify? Yes. And since that time then, have you made a decision?
Yes, ma'am.
And what is your decision?
My decision is, I was just.
I can't hear you.
I would like to.
You would like to testify?
Yes, ma'am.
All right, fair enough. Before we bring the jurors in, what are the number of felony convictions and misdemeanor crimes of dishonesty?
He only has 4 felony convictions.
Does the defense agree? So, Mr. Lawson, what that means is that one of the attorneys is going to ask you how many times you've been convicted of a felony. If you say 4, as everyone agrees, then they can't go into anything further. But if you say something different, then they will go into the facts of those convictions, okay?
Yes, ma'am.
All right, why don't you come on up to the witness stand before we have the jurors come in? And counsel will take a very brief recess at the end, then the defense can, make any motions that they wish to make. And then we'll come back for closings.
Your Honor, just for the court's awareness, at some point I will ask that Mr. Lawson briefly stand up just so we can say hi.
Sure, and he is not bolted on the witness stand, correct? All right, fair enough. I have no problems with that. And so because Dr. Radke was sitting on the witness stand and I asked him to stand to be placed under oath, I'm going to do the exact same thing with Mr. Lawson. Mr. Lawson, I'm going to ask you to stand up to be placed under oath. Even though I've already placed you under oath earlier, I'm going to ask the clerk to do that after the jurors get here, okay? So for now, have a seat, and then I'll tell you when to get up. You speak very softly, Mr. Lawson. It's important you talk loudly into the microphone, otherwise the jurors will not hear you, okay? So keep that in mind. Yeah, you can approach to adjust, and he can adjust too, because you can adjust that, okay?
Does he have cuffs?
No,
Okay.
he's not cuffed. So, yeah, you can use your hands and adjust the mic, okay? All right, any reason that the jurors should not be allowed to come in?
Nothing from the state, Your Honor.
No, Your Honor.
All right, or do not rise for the jurors to enter. Habits die hard. James, go ahead and bring the jurors.
Jury in the courtroom.
Welcome back, ladies and gentlemen. Please be seated. The state has rested its case. Does the defense wish to present any testimony?
Yes, Your Honor, at this time, the defense would call defendant Joshua Lawson.
All right, Mr. Lawson, if you will, please stand to be placed under oath by Madam Clerk. Please raise your right hand. Mr. Lawson, both the chair and the microphone adjust. Please adjust them so that you're able to speak loudly and clearly into the microphone, okay? You may have a seat. Ms. Kelly, your witness,
Thank you, Your Honor. Can you state your full name?
and I would encourage you to move your mic as well.
I apologize.
It's okay.
Can you state your first and last name for me?
It is Joshua Jamal Lawson,
Okay, what's your date of birth?
11/7/1995.
How old are you?
I'm 28.
48? Okay. So I'm just going to cut to the chase. When this incident occurred, you were an inmate at Graceville Correctional Facility, correct?
Correct.
Okay. So it's fair to say that you're a convicted felon.
Correct.
Okay. How many felonies have you been convicted of?
4.
Okay. And those were all, you were sentenced to those all on the same day? They were part of the same plea agreement?
Yes, ma'am.
So you saw the video that we saw earlier that was shown to the jury?
Right.
Okay. Prior to you being, you walking from your cell to Captain Sanders' office, had you ever met Captain Sanders before?
No, ma'am.
All right. Did you have any sort of animosity towards Captain Sanders?
No, ma'am.
Okay. Did you intend to hurt Captain Sanders at any point?
No, ma'am.
Okay. kind of, what, as you were going up there, kind of what led to this, to you go into Captain Sanders' office?
What led to originally was I was in the dorms. I was in the dorm and I was having my moment and I was using numerology. And
Mr. Lawson, I'm having trouble hearing you. Can you move the mic so that it's in front of you? And that way, when you're looking at Ms. Kelly,
Yes, ma'am.
perfect. Thank you.
so I was in the dorm, I was messing with numerology, and I was in the dorm, I was writing down numerology and studying it.
What is numerology?
Numerology is the study of numbers
Okay, so you were writing down numbers and studying them?
and studying them. And I end up putting letterology with it also.
All right,
I end up putting letterology with it also.
numerology and letterology?
You can pull it. It'll pull more. All right.
Right. Right. All right.
So you were studying numerology and letterology?
Yes, ma'am.
So you were just in your dorm and you were doing that?
Right.
Okay, so what happened from there?
So from there, the officer was doing his routine rounds. And then after that, he come in the dormitory and Officer Dosette.
Earlier today?
Yes. So after that happened, he comes in the dorm and he said, "Hey, what's wrong with you?" I say nothing. And I turned to go because I was snapping into the atmosphere of the dormitory.
We're just kind of talking out to
Right.
to the atmosphere?
Right. And he said, "Hey, I'm talking to you." I would turn around to go to my dorm, to the quad. Like, I'm already in the quad. Like they say, it was a quad, and then it's cell, initial cells. So I turn around and go to the cell, and he say, "Hey, I'm talking to you." So when he say that, I turn around and say, "Well, I'm not doing anything. I'm not hurting nobody. I ain't doing nothing to nobody." He just sat there and stayed there for 15 seconds. And then after that, his walkie-talkie go like static. And he asked me, "Oh, the captain do want to speak to you." I'm like, "I ain't hear that over the walkie-talkie." So when that happened, no ma'am,
Had there been any discussion of the captain wanting to speak to you?
no ma'am.
Right, so he, Lieutenant Joseph indicated the captain wanted to speak to you.
Right. And then after that, he sat there for 15 minutes, 15 seconds, excuse me. I'm sorry, for 15 seconds. And he said, "You want to go speak to the captain?" I said, "I'm sure, let's go." You know what I'm saying? And that's when he stated prior, when he said I had the pen. So when we go to the captain's office, we get there, he asked for the pen. Right. Officer Dosat asked for the pen. When he asked for the pen, I told him no. And then when I told him no, he's like, "So you're not gonna get him a pen?" I refused. And then I opened the back of the pen, the pen cap. I took the pen cap off. I closed the pen up, and I gave it to him. When I gave it to him, he went in there 4 or 5 times to go see to the captain, to come out and come speak with me, because he said he was dealing with a religious inmate, like he said, previously stated. So when that happened, the captain come out, he go to adjust his belt. And when he adjusts his belt, he come into my section, my personal area, and he's like, "Turn around, cover up." And then I'm like, "No, can you please let me know what I'm being pre-confinement for, so I can be able to write what I need to write, so I can be able to come out of confinement after you pre-confine me."
You were, correct me if I'm wrong at this point, and just for clarification, because I think it's a little hard to hear you. You were in your cell, just writing down numbers and letters.
Right.
Right, and Officer Dosick told you that the captain wanted to speak to you.
Right.
Right, then you went to the captain's office.
Right.
Okay, and then Lieutenant Dosick asked for your pen. You hesitated at first.
Right.
But you gave it to him.
Right.
Then he went into the captain's office.
Correct.
And the captain, after going back and forth, the captain came out.
Correct.
Okay, and then at that point, you said the captain came out and kind of adjusted his belt.
Correct.
Okay.
Correct.
Kind of towards you.
Correct.
Right. And then at that point, did you go towards the captain or just back up?
I backed up.
So kind of walk me through.
So after the captain come out, he adjusted his belt. So he got a little closer. When he get a little closer, I backed up and I hit the gate. When I hit the gate, I do hands gestures. "Can you please let me know what I'm being locked up for?" And all of a sudden, his glasses fly off his face. So I'm looking like, "Whoa, I ain't do nothing. I ain't touching." You know what I'm saying? So with that being said, my reaction is I'm stuck. He's stuck. And Officer Dosek is stuck. Now we're there like for 15 seconds. And when that happened, something just came over me, and I picked him up, Officer Sanders. I picked him up and placed him on his right side. So when I put him on the right side, he went to roll around on the ground. When he rolled on the ground, Officer Dosek told him, "Don't get up, don't move." You know what I'm saying? And then that's when I got sprayed, and when I got sprayed, I went straight to the ground.
How tall are you?
I'm only 5'5",
Okay. How much do you
like 140 or 149 right now.
weigh? Can you stand up for the jury?
Yes, ma'am.
You take 5'5",
Yes.
right? And you can sit back down. Was Captain Sanders a lot bigger than you?
Yes, ma'am.
Um,
I struggled with him.
So when you made contact with him, were you trying to fight with him, or were you trying to get back away? What was going on?
My basic initial my itinerary motive was to basically stay from confrontation, from physical combat, and from being restrained to the point where I'm getting hurt or I'm doing more damage than I was intended to.
Okay, so
Off instinct.
you were trying to prevent getting hurt yourself.
Right.
Do you ever intend to hurt anyone?
No.
Um,
After the slamming, I don't know if it was in the recording or not, but I pointed my finger at Officer Dosek, saying, "You're lucky because I'm not. That's not my intentions to commence further altercation or incriminate myself."
were you pepper sprayed physically?
Right.
Okay, was that before or after Captain Sanders?
That was after.
Is there anything else you want to jury to that?
No, ma'am. That concludes.
I don't have any more questions. Thank you.
Does the state wish to cross-examine this witness?
Yes, Your Honor.
Your witness, Ms. Jeffcoat.
Thank you, Your Honor.
If you two will, yeah, thanks.
So when this all happened, or before it happened, you were practicing, you said numerology and letterology.
Right.
And you were doing that in your dorm, correct?
Right.
Okay. And basically you're just writing down numbers and letters and those have meaning to you.
Right.
Okay. And then you made a comment that you said that you were having your moment. What does that mean?
Basically, the moment was the simple fact that prior to me being housed at Graceville, I was already in a erratic state before entering that compound. So basically, I was already like hostile and snapping out of control before I entered that compound facility.
Okay. So before you got to Graceville, you were already acting erratic and snapping.
Right.
And were you snapping and acting erratic when Officer Dosick came to the dorm?
Right.
Okay. And when Officer Dosick, he asked you to cuff up, right?
No, he didn't. He didn't.
And I don't want you to tell me what your sentence was. I can't ask you that, but that wasn't your first day at that institution, correct?
No.
And officers have asked you to cuff up before, correct? You've had to put cuffs on inside the facility before, right?
Right.
And so for whatever reason, though, you and Officer Dosick go to talk to Captain Sanford, correct?
Right.
And this was your first time meeting Captain Sanford?
Yes, ma'am.
So he had never done anything to you in the past or anything like that?
No, ma'am.
Now you watched the same video that the jury watched, correct?
Yes, ma'am.
All right, and that's you on that video with Captain Sanford and Captain Dosick and Officer Myrick, or I'm sorry, not Captain Dosick, Captain Sanford and Officer Myrick and Officer Dosick, correct?
Yes, ma'am.
For
Um,
clarity of the record, Sanders?
Sanders, I'm so sorry.
No, it's all right. I just wanted to clear record.
But that was you and the officers on that video, correct?
Yes, ma'am.
And the jurors, you saw just like the jurors did that you tossed Officer Sanders over your shoulder, correct?
Right.
And you would agree that when you did that, he went to the ground and he didn't get back up, correct? You saw that on the video.
Right. Because of the statement that the officer initially told him to stay on the ground.
So it's your testimony that he stayed on the ground, but it wasn't because of his injury. It was because Officer Dosick instructed him to stay on the ground.
Right. He told him not to get up.
Do you know of any reason why Captain Sanders would have followed Officer Dosick's? And if that was an instruction that was given, why would Captain Sanders have done that?
To my knowledge, I wouldn't understand that. So
Fair enough. And you would agree, though, that Captain Sanders ended up being injured, correct? You heard the testimony from the doctor?
right, but I have no knowledge of his death until after I got away from the facility.
Okay, so after this incident, you were transported to a different facility with the Department of Corrections, right? Okay, and then later on, you found out how bad the captain had been injured,
Right.
correct?
Two institutions after that.
Okay.
I found out.
Okay, you moved a couple of different times.
Right.
All right. But you would agree, though, that Captain Sanders, the testimony is that Captain Sanders died as a result of the injury to his leg,
Yes, ma'am.
correct? I don't have any other questions.
Any redirect of this witness?
No, Your Honor.
All right. Ladies and gentlemen of the jury, there is some matters that we need to consider outside of your presence, but it should not take more than just a few minutes. So if you will please retire to the jury deliberation room, we will bring you back out in just a few minutes. Yep, let's leave the notes here. James, for confirmation, our white noise machine is still on, correct? Thank you. Let the record reflect that the jurors have exited the courtroom, however, still present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. We can move the defendant into his chair. Does the defense anticipate calling any additional witnesses?
No, Your Honor.
Do you anticipate resting at the next opportunity?
Yes, Your Honor.
All right, let's go through our charging conference and make sure that the jury instructions are as they should be. Will you put them up on the screen, or do you not want to do that?
Oh, no, Your Honor, I can pull them up on the screen.
All right,
I think that's the easiest. And I did email a fresh copy.
I have an emailed copy, so that's great. Will you put prosecutor PC on Polycom? You with me? Perfect. So instead of camera quad under Polycom, put prosecutor PC. Got it. Thank you. All right. Instruction number 1, introduction to the final instructions. Any objections? Ms. Kelly?
No, Your Honor.
As the state has prepared these instructions, the court assumes that the state is agreeable to the contents. So just jump in, Ms. Jeffcoat. Statement of the charge, any objection?
No, Your Honor.
Introduction to homicide, any objection?
Just for clarification, these haven't been amended in any way since.
The only ones that I changed since is I actually changed the font size and the boldness
For all of them.
for everything.
It
so
looks
that
like.
would all match. And then I removed that one sentence regarding the culpable negligence that we had discussed, that injury was not
Okay.
required. Okay, but none of this instruction has been changed.
All right, that'll save me from reading it line by line.
Understood.
Sure. So any objection to that proposed instruction?
No, Your Honor.
Ms. Kelly? How about the second page of that introduction to homicide?
No.
Now, is the last sentence there, should that be Josh Lawson may be found guilty of manslaughter, or should it be aggravated manslaughter?
Does it say manslaughter throughout? Oh, no, it says aggravated manslaughter. I think it should probably be changed to match. Well, there's 2 places where I think in that third.
Let me go to the standard. Let's see if that's a place where you're supposed to change the instruction.
The beginning of that instruction, I know it makes you select the degree and then edit it so that you only have the lesser included for the degree that was charged, because it applies basically to all homicides.
It says, for that last paragraph, it says, I now instruct you on the circumstances that must be proved before defendant may be found guilty of crime charged. And the crime charge is aggravated manslaughter, so that needs to be changed.
Does it need to be changed in that second paragraph as well, Your Honor? I think I just have
That's all right, let me look.
the second and
So the second paragraph in the standard says first degree murder includes the lesser crimes of second degree murder, murder, and manslaughter, all of which are unlawful. Therefore, I think the way that should read is aggravated manslaughter is unlawful.
Quick one. I am uploading this as its own. I'm uploading this as its own video as well. So if you want to skip instructions, I can. Just let me know relatively quickly, because I'm just taking a second to let something upload and then I'm going back to concentrating. So just say yes or something in the chat, or no, whichever.
Or it should read aggravated manslaughter includes the lesser crimes. But now there's no,
Mel, to be honest, I'm actually kind of confused about it as well. But I think it was internal bleeding. 2 votes for skip. Any votes for not skip? 5, 4, 3, 2, skipping.
the evidence and testimony you're going to receive in
All right. Now, Ms. Kelly?
Change 3 to the law enforcement officer is a one split second.
Reasons or anything else before we bring the jurors in?
Nothing from the state.
Anything from the defense?
No, Your Honor.
All right, let's all remain seated. We'll bring the jurors in and we'll start closing arguments. Give me 1 second, James, to get to that instruction.
Yes, all, Your Honor, at this time, can all witnesses be released?
Any objection?
No objection.
So ordered.
I think I was halfway through a thought, but yes, exactly what Steve is saying. And actually, my cousin was saying that it's crazy how many people die from a broken hip because they don't realize that it's broken, and there's internal bleeding. So, but it sounds like the defense was saying the doctor should have picked it up. It is hard to break your femur. It is its strongest, I think.
Let's wait for them to come in. That way our closings, guys, do your best to talk into a microphone so that everyone can hear you. And Chuck, will you point that microphone towards the speakers so that the one by the jurors?
I need to renounce that we're resting with the jury.
I'm going to ask you to. Are any or any witnesses coming in? Okay, let me wait on Rory, or maybe not because he's bringing the instructions, right? Okay, I think they're coming. Great. All right, let's bring the jurors in. Everybody remain seated, please. Welcome back, ladies and gentlemen. Please have a seat. Ms. Kelly, does the defense wish to call any additional witnesses?
Your Honor, at this time the defense rests.
All right. Ladies and gentlemen of the jury, both the state and the defendant have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding this case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Any objection to the reading of standard instruction 2.7?
No, Your Honor.
Is the state ready to proceed? You may proceed.
Members of the jury, at this time, you have seen and heard all of the evidence and testimony you're going to receive in this case. And the state and the defense will put forth our arguments as things that we think you should look at, things that you should consider in making your decision. The evidence before you is without doubt that but for the actions of the defendant, Joshua Lawson, Captain Sanders would not have had his femur broken, would not have had a blood clot, and would not have died on March the 18th as a result of a pulmonary embolism that resulted or originated from the femur that was broken during the incident with Joshua Lawson. Members of the jury, the judge is going to read you the instructions on the law that you're to follow. I want to go over some of those with you at this time. I won't go over all of them. Something to keep in mind is that while the instructions are long, they're very important. And the judge is actually going to give you a paper copy of the instructions that she reads to you. So you don't have to worry about writing it down while she's talking. You'll have a paper copy to take in the back while you deliberate. If for any reason what I say or the defense attorney says is different regarding the law to what the judge reads, it's the law that the judge reads you that you're to follow. We always try to be as accurate as we can, but just in case, you always should follow the law as the judge reads it. So, the defendant, as you know, is charged with aggravated manslaughter, and it's aggravated manslaughter of a law enforcement officer. There are several lesser included offenses that you will be asked to consider by the court. Those include.
Let me stop you. I believe our TV stopped. Were you trying to broadcast something? Is it broadcasting here, Chuck?
No, I think we need to put prosecutor PC.
Prosecutor PC to the TVs. I apologize for the interruption.
Oh, no, I'm sorry. Actually, notice that that's.
Are you still plugged in?
I am.
It's showing on the.
There we go. It was showing on that one, but not, okay. All right.
So
There we go.
let me just back up. All right. So, as you know, the defendant is charged with one count of aggravated manslaughter of a law enforcement officer. There are lesser included offenses that you see on the list before you, and the court will ask you to consider each and every one of those. Lesser included offenses are essentially crimes that are completed on the way to committing the primary offense with which the defendant is charged. So the ones that you will be asked to consider today are manslaughter, aggravated battery on a law enforcement officer, felony battery, battery on a law enforcement officer, simple battery or just battery, and culpable negligence. And I want to go through each of those with you just so you can see some of the difference. And it's usually easiest to start with the least serious offense and then kind of work your way up because you'll see how they kind of build upon each element. So every crime has certain elements the state has to prove, and the standard of proof is beyond and to the exclusion of every reasonable doubt. So culpable negligence has two elements. The first element is that Joshua Lawson inflicted actual personal injury on Matthew Sanders, okay? And the second element is that he did so through culpable negligence. And we're going to go through, we're going to talk about culpable negligence some more, but it's more than just an accidental injury, okay? It has to be through some gross and flagrant behavior, some actions that would indicate that he had a disregard for the safety of Mr. Sanders. And I'm going to talk about this next, the next two kind of together because the elements are essentially the same. They have the same first element and then they build. So to prove the crime of battery, the state would have to prove that Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. And to complete a battery, and we sometimes call this a simple battery, it's any touching or striking that is against the will of the victim, any unwanted touching. So literally poking somebody, pinching somebody, shoving them in the shoulder. Those are all ways that battery can be completed. Even spitting on a person is considered a battery in the state of Florida. So certainly we have evidence that there was a touching. And then the second, if you were to the first element is the crime of battery. To prove the crime of battery on a law enforcement officer, there's a second element. The first element is just the same as the one we just read. And then the second element is that Matthew Sanders was a law enforcement officer. Now, in the instructions that the judge will read you, there will be definitions, and it will explain that a corrections officer is a law enforcement officer for these purposes. And then the third element to prove battery on a law enforcement officer is that Joshua Lawson knew Matthew Sanders was a law enforcement officer. We heard repeated testimony about him being referred to as Captain Sanders. We know that he was told that he was going to speak with Captain Sanders. We could see the video where the officer was wearing his uniform. And so the defendant would certainly have known of Matthew Sanders' status as a corrections officer. Okay. Now, let's go on to felony battery. So felony battery, you're going to, I'm sure, recognize that first element because it is the same as it was for the crimes of battery and battery on a law enforcement officer. And that is that Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. So again, this touching or striking, it's not an accident. It's not I tripped and I accidentally pushed you or hit you. It is purposefully making contact with another person. And then that the second element of that is that Joshua Lawson caused Matthew Sanders great bodily harm, permanent disability, or permanent disfigurement. All right. So the next thing we're going to talk about then is felony battery. Felony battery is similar, aggravated battery, I apologize. Aggravated battery is similar to felony battery. Okay, and again, you'll recognize that first element that the defendant intentionally touched or struck the victim. But the next element, again, is a little bit different than in felony battery because the difference between aggravated battery and felony battery is not just that when the person was touched or struck and that they received great bodily harm, it's that the defendant intentionally caused and knowingly caused great bodily harm. Okay. And then this is aggravated battery of a law enforcement officer. So the third element would be that Matthew Sanders was an officer. And again, there'll be a definition that will include Matthew Sanders' status as an officer and that he was a corrections officer. So I want to talk to you a little bit though about that second element about intent. Okay, intention. Somebody's intentions are an operation of the mind. There's a couple of different ways though that you as jurors can determine how what a person's intentions are. And by operation of the mind, I mean it's something that's going on in a person's head. So there's a couple of different ways. One, a person can tell you that, well, you know, when I struck the match, I meant to set the firework on fire. Okay. So that's one way to determine a person's intent. And then once they've told you that, you can either as jurors decide whether or not you believe what the person says. Okay. They could be telling the truth. They could be lying. Another way though, to determine what a person's intentions are by watching their actions. And so remember when we talked about the fireworks display and jury selection, if you see me strike my match and then put it down to the fuse on my bottle rocket, you can determine without me ever telling you that I intended to light that match. Okay. So how does that apply to the case at hand? Well, we saw the video, we've heard testimony, we've now heard the testimony of the defendant, okay? And he says that he did not intend to harm the officer. He acknowledges that he did toss the officer. He acknowledges that the officer died, you know, as a result of the injuries he received, but he says that he did not intend to cause those injuries. Well, what would one think would happen when you throw a person onto a concrete ground, okay, a concrete floor? So is it foreseeable that a person would be seriously injured as a result of being thrown to a concrete floor? And this wasn't just a simple pushing. He went over the defendant's shoulder onto the ground. And so it was a very hard fall. And we know from the testimony that it was hard enough to fracture Captain Sanders' femur bone, which ultimately led to his death. So from the circumstances of this incident, you as jurors can make a determination that the defendant intentionally and knowingly caused great bodily harm to Matthew Sanders because his actions, it wasn't just a push in the chest, get away from me. He flung him to the ground and the resulting injury is certainly foreseeable. And then, of course, the fourth element, again, similar to the battery on a law enforcement officer, is that Joshua Lawson knew that Matthew Sanders was a law enforcement officer. And we talked about that already about what he would have known on that compound at that time.
And then there's a fifth element, is that Officer Sanders, or Matthew Sanders, was engaged in the lawful performance of his duties when the battery was committed against him. And so we know from the testimony that he went to work that day, that he had worked for the Department of Corrections at that institution for many years, and that he was a captain at that facility, and that Officer Dosick, in dealing with the defendant, had taken him to see the captain as part of their kind of escalation of dealing with an inmate who was having some issues that day. And we'll talk more about that shortly. So the next lesser included offense, and this will be the last lesser included offense before we talk about the primary charge, is the crime of manslaughter. So to prove the crime of manslaughter, the state must prove that Matthew Sanders is dead. And certainly we heard testimony from the medical examiner, as well as from Captain Sanders' widow, Mrs. Sanders, about his death, and that he died on March the 18th of 2021. There's two different ways that the state can prove element 2. So this is something to pay maybe extra attention to. So the first way that element 2 can be proven is that Joshua Lawson intentionally committed an act or acts that caused the death of Matthew Sanders. Okay. So again, here's that word intent. Now, the state does not have to prove that he intended to cause the death of Captain Sanders. If we were trying to prove that he intended to kill Captain Sanders, he would be charged with first-degree premeditated murder. That's not what he is accused of. But he is accused of intentionally throwing Captain Sanders, kind of hurling him over his shoulders or slinging him to the ground. So that is the intentional act, which ended up ultimately causing the death of Matthew Sanders. The second way, and then because there's an or the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. So we have manslaughter by act, meaning that Joshua Lawson committed intentional act. And then we also have manslaughter by culpable negligence, meaning that the defendant committed a negligent act which resulted in the death of Captain Sanders. And we'll talk about culpable negligence in more detail in just a moment. We already went through this one. Let's see here. All right. So this is the primary offense with which the defendant is charged, and that is aggravated manslaughter. And so again, the state has to prove that Matthew Sanders is dead. And then the second thing we have to prove is that the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. And then 3, that at the time that Matthew Sanders was an officer, Matthew Sanders was an officer at the time that this occurred, and he was performing his legal duties. Okay. So those are the 3 things that the state has to prove, is that the victim is dead, that the death was caused by the defendant's culpable negligence, and that at the time of the incident that led to the death, that the officer was in fact an officer and performing his legal duties. So let's talk more about culpable negligence, because I know that that has come up in a couple of our instructions. And so culpable negligence, the instruction that I anticipate the judge will read to you says that every person has a duty to act reasonably towards others. If there's a violation of the duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human lives or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to the consequences, or which shows a wantonness and recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. Okay, so let's talk about that some more, and then we'll talk about that last one. So the defendant's actions, and I'm talking specifically about not just his actions towards the officer that day, but his general mood. The first officer that testified, he got called out there initially because the defendant was refusing to have cuffs placed on him. And by the defendant's own admission, he was having a moment. He was acting erratic, I believe, were what his words were. And this is according to the defendant. He was having a moment, snapping off, and erratic, and that was even before he got into the institution. And then he said while he was working on his numerology and his letterology, that he was snapping off at that time. And so there's an issue that requires Officer Dosick to come out there. But at the time, he is somewhat amenable. He knows what's going on because he agrees to go with the officer to meet with the captain, and he doesn't have to be hauled down there or dragged down there. But apparently when he is meeting with the captain, he is still having some issues because the request is simple at this point from the captain. It is to cuff up, which is a standard, practice at a DOC facility. And this wasn't his first day there. He had been cuffed before. And so when they try to cuff him, he ends up, picking the officer completely off of the ground. And the officer is bigger than the defendant. There's no question about that. But he ends up picking him up and bringing him down with enough force to cause major and serious injury. Okay. And so that behavior of throwing another human being onto a concrete floor in that way was grossly careless. It certainly did not have any regard for the safety of Captain Sanders. And while there's no evidence that he intended to kill Captain Sanders, that was ultimately the result. And so the third part of culpable negligence is that the negligent act or omission must have been committed with an utter disregard to the safety of others, which again, he was not concerned about the safety of the officer. And
and it is consciously, it says that culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. And again, in this situation, the defendant should have known or reasonably should have known was likely to cause this great bodily injury to Captain Sanders. And that is exactly what happened. Members of the jury, there is no other evidence that Captain Sanders died from anything but the actions of the defendant, Joshua Lawson. And so I know that the doctor was questioned about, Captain Sanders' prior medical conditions and all of these different things that could cause a pulmonary embolism, and some of which there's no testimony that he even had some of those issues. But the uncontroverted testimony is that the plot which ultimately killed Captain Sanders originated from the broken femur, which occurred on March the 18th when Joshua Lawson threw him onto the concrete sidewalk there in the DOC facility. So with that, members of the jury, I will ask you to find the defendant guilty of the offense of aggravated manslaughter. Thank you.
Is the defense ready to proceed?
Yes, Your Honor.
Ms. Kelly, you may proceed.
Thank you, Your Honor.
Thanks, Steve. I'm also very confused about this one. 8 minutes, that was, so he's going about 6 minutes. Do we pause here and watch the defense's closing and then the verdict later? Do you guys want to head over so long? I don't know if I can redirect if he's not live yet. Let's try. I think I can. It's hard to tell if the corrections officers were on a power trip. Also, the video that I wrote about Texas storms has been published. I can post the link if you want to see. It's not the usual channel I work on. It's the one I'm the developmental editor for. I also saw a question about memberships. You should be able to do memberships, but the thing is that they are saying my AdSense is paused because my bank card expires on the 30th, so 2 days' time. And they want me to upload ID, proof of ID and stuff, and it's just not accepting it. So, so many commit crime and not own up to it. It happened, but the clot, yeah. It is a tricky one. It is a tricky one. And that's true. These are, both of those statements are true. And I think that's what, and I can't remember how long the jury deliberated for because I cut it out. I should have taken down the times first. Okay, guys, are we gonna 28. I think it's probably smarter to head there because I don't want to start anything. But please don't be confused if you see this premiere tomorrow. I put it as a premiere because YouTube likes that. I don't know. Testing things out. I've done this with a few different videos, not on my channel, so I kind of know the ropes a bit, but I'm also kind of confused about the charges. Anyway, let's see. If we go live later today, maybe during lunch, then I need to know everyone's wins for the week. Mine is I've smashed work this week, like smashed it. I also want to do the raid. Here's the only thing about the raid. If we do it before he starts, then nobody sees it. And then it jumps because of the seat thing. Let's see. He might be late. 2 minutes 22. Also, I'm pretty sure there's going to be a verdict today. I don't think that they will. I don't think they'll go over the weekend. I highly doubt it, and I don't like the idea of juries going over the weekend. Yes, I had a task list that I felt when I started the week was maybe a bit, can you tell I've been writing? My brain's like no words left. Is it a long weekend? Is Monday a holiday? If Monday's a holiday, it means it's mine and Vaughn's anniversary. What was I saying? I've totally forgotten. I don't like jurors going to the weekend. Also, I sound like I'm getting sick, but I think it's just allergies. I've gone blank. Oh, you need to send your wins. Oh, yes, smashing work. So I had a to-do list like this long, and I got tasks ticked off like boom, boom, boom. And I'm going to keep going. I have 2 scripts I want to wrap up today. Another script I want to edit today. Got to move it tomorrow. Oh, there's already. Oh, okay. Okay, let's head over. Let's raid. He's in my ear. Okay, so if Thursday's a holiday, maybe we'll stream a whole trial that day. Let's see how it goes. See you guys there. Bye.